Both states agree that those circumstances are an indicator pointing towards the June 2024 finance agreement being legally binding. And both states also agree that the fact that the binding asylum partnership agreement provided the context in which the June 2024 finance agreement was agreed is a similar indicator. And that brings us to Judge Donohue's question to both parties. There are, of course, factors in the June notes at June that the intention was not to create binding obligations. And the tribunal will have noticed the use of the word will rather than shall in 1.6 and 2.3, and the use of intended to be in 2.3.1. On the other hand, as Rwanda pointed out yesterday, they contain a dispute settlement clause at 6.1, providing that disputes that may arise as to the interpretation or application of them will be settled by reference. For the main claim before this tribunal, it is that provision in 6.1 which confers jurisdiction on the tribunal. It's not Article 22 of the treaty considered alone. A binding award on a non-binding instrument would be an odd creature. Taking into account those factors in the round, together with the other relevant indicators explained in Gabon Equatorial Guinea, the United Kingdom does not in this case contest the aspect of Rwanda's claim that the June notes conferred payment obligations on the United Kingdom. The crucial point arising from all of that is that Rwanda is quite wrong to seek to apply a higher standard to the November notes when they were concluded in the context of and in order to amend the June notes. That takes us, members of the tribunal, back to the chronology, unless I can assist further on that topic. At slide 18, we find C26. After the change in government in the United Kingdom in July 2024, Rwanda explicitly recognised in a note to the United Kingdom that either party may terminate the asylum partnership agreement. And of course, the 2024 finance agreement provided that it would terminate at the same time as the asylum partnership agreement. That's paragraph 5.1. The government of Rwanda made the same acknowledgement publicly in a press release on the same day. That's C27. Also, on that same day, it's 8 July 2024, the United Kingdom informed Rwanda by note verbale that no future removals of individuals to Rwanda under the MEDP are scheduled or intended to be scheduled, and that the United Kingdom would be considering the issue of formal termination in due course. So at this point in the chronology, 8 July 2024, I just pause to consider 5 factors. The first is that by this point, Rwanda had already received payment of 270 million British pounds in ETIF payments from the United Kingdom. That total amount was paid in parts in April of 2022, 2023 and 2024. And receipt of that 270 million pounds is common ground. That's the statement of claim at 26, and you see C13 on your screen. The second factor is that only 4 individuals had been relocated from the United Kingdom to Rwanda pursuant to the Asylum Partnership Agreement. The third factor is that the new government of the United Kingdom was clear that there would be no future relocations under the Asylum Partnership Agreement from the United Kingdom to Rwanda. The fourth is that both states had a unilateral right to terminate the Asylum Partnership Agreement, and thus the June 2024 Finance Agreement, and Rwanda had specifically recognised that unilateral right. The fifth factor is that in April of 2025, a further £50 million would fall due, and in April 2026, the same again. With those 5 factors in mind, it is simple common sense that either by way of unilateral termination or some other agreement, those further payments were not going to be falling due. The June 2024 Finance Agreement concerned financial arrangements for the relocation of individuals to Rwanda. We saw its paragraph 1.3 specifically on its purpose. From 8 July 2024, it was clear that there were going to be no further relocations from the United Kingdom to Rwanda, and so it was entirely logical that obligations to make further ETIF payments would be terminated. And that brings us, members of the Tribunal, to the content of paragraph 60 of Rwanda's Statement of Claim. In paragraph 59, Rwanda finished the preceding section discussing the events of 8 July 2024, which we have just been considering. Paragraph 60 then contained only one sentence. It said nothing was heard from the UK for several months. And paragraph 61 deals with the 13 November 2024 initiating note verbale from the United Kingdom. It starts with the word then, suggesting that was the next thing that happened. Rwanda was affirmatively representing to the Tribunal in its Statement of Claim, in these paragraphs, that from 8 July 2024 to 13 November 2024, it had heard nothing from the United Kingdom. That mattered because Rwanda's case appeared to be that when Rwanda read the UK's note of 13 November, it was receiving the UK's proposal for the first time and replied that it was acceptable in principle, but not actually accepted. Rwanda has now apologised, and I propose now, members of the Tribunal, to concentrate on the detail are now relying. At slide 25, we see the note verbale announcing the visit of a UK delegation to discuss logistics and timelines for UK withdrawal. That same message was conveyed in the note verbale at R14 the next month, when the members of the UK delegation were identified. R15 is the 3 October 2024 UK internal note of the first discussion between the states of which there is evidence. The Tribunal might look again at the heading concerning the 2025 ETIF payment, DVAs and airside transit visa waivers. And under that heading, it says that these issues appear inextricably interlinked. You were taken to that yesterday. But that does not mean, of course, that any legal obligations that might be altered or created were so linked. And it doesn't mean that even as a matter of discussion, they stayed linked. It was already clear at this stage that the UK would in one way or another terminate the ETIF time for its domestic process. But it is also very clear that without such an agreement, the legal process in the United Kingdom Parliament would need to occur, followed by a formal termination notification to Rwanda. The next day, on 9 October, there is a further internal Rwandan email, it's C44, submitted with the reply, that says, in exchange. But it is also clear that what was under discussion was the treaty termination timeframe, not whether it would be terminated. There was evidently an interministerial meeting in Rwanda on the subject the following day, but we have no evidence concerning what was said at that meeting. We do have C45, which is titled DVA Offer to the Government of Rwanda. This is from the United Kingdom to Rwanda. It refers back to the 3 October meeting between the Home Office and the Government of Rwanda. And it says in the second line that the UK looks forward to exploring the details of a new UK-Rwanda DVA. It then sets out what it terms offer details, and in the final bullet point on the page, it says changes to implement the Rwanda offer will require amendments to the published immigration rules, and that in a passage to which you were not taken yesterday, it was unlikely for this to be feasible before spring 2025. Still on 10 October, but now at R16, after that email, and in the evening of the day of the Rwandan interministerial meeting, there was a call between the UK Home Secretary and the Rwandan Foreign Minister. The United Kingdom has provided its internal note of the call, which says it was agreed that Rwanda would sign an NV that removes the obligation to pay any further sums under the ETIF, and a short time frame was being envisaged. The next bullet point is about DVAs, and they were to be extended in the spring, so some 5 months hence. The note finishes indicating that once the notes are agreed and signed, the Home Office would inform parliamentary authorities that it would no longer need to bring forward the repeal of the Safety of Rwanda Act, which was seen as the domestic prerequisite to terminating the treaty on the international plane. At C42, Rwanda has now provided its own internal note of that same call, so the tribunal can helpfully see the internal records of each state of the same conversation between ministers, and Rwanda relied on parts of that note yesterday. Paragraph 3 refers to the legislative process to repeal the domestic statute in the UK, and notes that because of the time that could take, the UK requested a commitment of Rwanda to not seek the payment of the £50 million due in April 2025. The word Rwanda recorded for its internal purposes was commitment. Paragraph 4 records the Rwandan Foreign Minister assuring that Rwanda will, in principle, not pursue that payment, provided that the UK follows the right legal procedure. This is on slide 33.
Maybe you can wait for a minute. I think we have some technical issue. We do not see on the screen anymore documents you wish to refer to. Now it works, please continue.
It's always a joy when the problem is hardware rather than software. Paragraph 4 records the Rwandan Foreign Minister assuring that Rwanda will, in principle, not pursue that payment, provided that the UK follows the right legal procedure. Rwanda, in its reply and yesterday, focused on this part and says that this is far more nuanced than the UK's use of the word agreed. Let's just assess that by looking at the remainder of the document. The Foreign Minister then asked what legal documentation the UK would provide. And paragraph 5 records that the Home Secretary wished for there to be a note verbale from the United Kingdom requesting Rwanda to forego the £50 million payment, to which Rwanda would respond by a note verbale accepting it. She said that the United Kingdom would send a draft the next day. Paragraph 5 then says that the Home Secretary added that to show the strong partnership, the UK is willing to facilitate visa waivers for up to 100 diplomatic passports per year. Further revised version is at R27, but there is again no need to go to it because the only changes concerned the use, reimbursement and reporting on the various parts of the £20 million that had been paid